A specific document exists that overrides your testament every single time. If you haven't reviewed it within the past year, your whole legacy plan might already be directing your assets to someone you never intended. It matters not how much your lawyer charged you. It matters not how meticulously your testament was created. It matters not if you adjusted your testament last month. If this specific document states something different than your testament, this document prevails. Not occasionally. Not in particular regions, every single time. National courts have confirmed it. Regional courts have confirmed it. The United States Supreme Court resolved it collectively. The document overrides the testament. But here is what your legacy lawyer likely never mentioned. There is not simply one of these documents. There are at least 5 different types hidden inside accounts you currently possess. And the most hazardous one is inside an account most retirees have not viewed in over a decade. By the conclusion of this presentation, you will understand exactly where all 5 are located, what they manage, and the one oversight that transforms a basic document into a 400,000 catastrophe for your kin. This document is labeled a beneficiary designation. You completed one the moment you started your 401k at employment. You completed another when you purchased your life coverage policy. Your bank might have requested you to complete one. Your brokerage might have one on record. You authorized these documents years ago, likely never contemplated them again. And that is exactly where the issue begins. A beneficiary designation is a formal agreement between you and the financial entity that manages your funds. It informs that entity one thing who receives the funds when you pass. And when you pass, the entity observes that document. Not your testament, not your trust, not your handwritten note, not a spoken vow you made to your offspring at the dining table. They observe the document because legally the document is an agreement, and agreements override testaments. And here is the element that makes this so hazardous. The financial entity does not investigate. They do not contact your kin. They do not examine your testament. They do not inquire whether the individual on the document is still the individual you would elect today. They spot a name, they transmit the funds, and once those funds are transmitted, reclaiming them is nearly impossible. This is not a technicality. This is national law. Let me demonstrate how poorly this can conclude. A gentleman named William Kennedy served at DuPont for over 20 years. He possessed an employer pension plan valued over $400,000. When he initially joined the plan, he designated his spouse as the beneficiary. That seemed logical at the time. They were wedded. She was the natural selection. Years later, they separated. After the separation, Kennedy did what most accountable people do. He visited his lawyer and modified his whole testament. He made it perfectly transparent. Everything goes to his daughter. He authorized it. It was certified. It was legally legitimate in every manner. But he never contacted DuPont to modify the beneficiary designation document on his pension plan. He might not have even recalled the document existed. It was a bit of bureaucracy he authorized 2 decades prior on his first day joining the plan. When Kennedy passed, his daughter believed the funds were hers. The testament said so in simple terms. There was no confusion, but DuPont transmitted the entire $400,000 to the ex-spouse because the beneficiary document still carried her name on it. Kennedy's daughter litigated. She possessed the testament. She possessed her father's transparent goal. The matter moved through the national courts and eventually reached the United States Supreme Court. The court concluded collectively. The beneficiary designation document manages the testament is pointless. The daughter obtained nothing. $400,000 lost because of one document he neglected to modify. And this is not unusual. A research by the American Association of Retired Persons discovered that nearly 40% of Americans with pension accounts have not modified their beneficiary designations in over 5 years. 40%. That means millions of retirees right now have documents on record that do not show who they truly want to obtain their funds. Separations occurred, remarriages occurred, partners passed away, grandkids were born. Life shifted in every conceivable way. But the document remained stuck in time because nobody seized the phone and modified it. Consequently, the inquiry every retiree needs to resolve right now is not whether your testament is current. The inquiry is whether every beneficiary designation across every account you possess matches what your testament actually says. Because if there is a lone mismatch between the two, the document prevails and your kin loses. Here are the 5 locations these documents are hidden right now. Number 1, your 401k or 403b. If you ever serve for a corporation, a school district, a clinic, or the state, you have a pension plan with a beneficiary document on record. The median 401k total for Americans between the ages of 60 and 69 is $232,000. That whole total is managed by the beneficiary document. Your testament does not affect it. Your trust does not affect it. The document is the loan record that counts. Number 2, your IRA. Conventional Roth, SAP, it does not matter. Every IRA has a beneficiary designation. And here's the snare that ensnares more retirees than almost anything else. If you shifted your old 401k into an IRA when you retired, the beneficiary designation did not shift over with it. That old document remained at your old firm. When the funds arrived in the new IRA, you authorized a fresh beneficiary document at the IRA firm. Perhaps you completed it carefully. Perhaps you marked a box in a hurry because it was one of 15 documents they gave you that day. If you do not recall exactly who you designated on that fresh document, that is the issue. Number 3, your life coverage policy. The median life coverage death payout in the United States is $350,000. That settlement goes straight to whoever is on the beneficiary document. And life coverage policies are where this issue gets the most distressing because people purchase these policies young and maintain them for decades. A lady in Ohio lost her spouse after 32 years of matrimony. He had a $250,000 life coverage policy. She believed it was hers. They had been together for over 3 decades, but her spouse had originally bought the policy during his first matrimony and had designated his first spouse as the beneficiary. He never modified it after the separation. He never modified it after the remarriage. For 32 years, that document sat in a storage unit with the incorrect name on it. His second spouse, the lady who spent 32 years by his side, obtained nothing. The first spouse, who he had not contacted in decades, received the check within 60 days. Number 4, your bank accounts. Most banks provide a tool called payable on death, and many retirees enroll for it without fully grasping what it does. A payable on death designation transmits your whole bank total straight to the designated person when you pass. It avoids probate completely. It also avoids your testament completely. You might have added this to your checking or savings account years ago because the bank advised it as a basic way to bypass probate. But if the person you designated is no longer the correct selection, or if your kin situation has shifted, this document is quietly trumping your whole legacy plan right now, and nobody knows it until you are gone. Number 5, this is the most hazardous one I cited at the start of the video. Your brokerage account. If you have stocks, bonds, mutual funds, or ETFs at a company like Schwab or Fidelity or Vanguard, there might be a transfer on death sign-up on record. Some of these accounts possess $300,000, $500,000, even over $1 million. This document transmits the whole account total straight to whoever is documented, with no legal intervention, no probate procedure, and no contribution from your testament whatsoever. Retirees who established these in their 50s and never viewed them again are perched on a ticking time bomb for their families. And because brokerage accounts often expand notably over the decades, the sum at risk today might be 3 or 4 times what it was when you originally authorized the document. Now, let me show you the 4 errors that cost families the most funds. The first error is naming your estate as the beneficiary instead of an actual person. This sounds sensible, but it is one of the most pricey mistakes in legacy planning. When you designate your estate, the pension account gets dragged into probate. That means lawyer fees, legal costs, and holdups of 6 months to over a year. But the real harm is the tax blow. When a partner inherits a pension account straight through a beneficiary document, they can shift it into their own IRA and keep postponing taxes for decades. When the estate inherits it instead, that partner shift option vanishes entirely. On a $300,000 IRA, this one error can spark over $75,000 in accelerated national income taxes that your kin would not have owed if the document had simply listed a name instead of the estate. The second error is never modifying after a separation. In most regions, a separation does not automatically delete your ex-partner from a beneficiary designation. Some regions have rules that cancel a partner upon separation for certain types of accounts, but the regulations are highly erratic and they do not apply to employer pension plans that are regulated by national ERISA law. National law trumps regional law in those instances. If your ex-partner is still on the document, believe they are obtaining the funds until you contact the firm and verify otherwise. The third error is naming underage children or grandkids straight. If you list a kid under 18 as a beneficiary, the financial firm cannot legally give them the funds. A court will have to designate a legal caretaker to handle the assets on the kid's behalf. That sparks court scrutiny, annual reporting duties, lawyer involvement at every phase, and caretaker fees that can consume $20,000 to $30,000 out of a $200,000 account before the kid ever views a penny of it. The fourth error is the one that transforms all of this into a tax crisis. Before the year 2020, if your kid inherited your IRA, they could prolong the payments over their whole existence. A 45-year-old inheriting a $500,000 IRA could take small payments over 4 decades and let the rest of the funds continue to expand, tax deferred. But lawmakers shifted the rule. Now, most non-partner beneficiaries must drain the whole inherited IRA within 10 years. Let me put actual figures on this. Suppose you have a $500,000 conventional IRA and you leave it to your son who earns $120,000 a year. Under the 10-year rule, he must drain the whole $500,000 within a decade. If he takes $50,000 per year, that elevates his annual taxable income from $120,000 to $170,000. At that mark, he moves from a 24% national tax tier to 32% on those payments. Over 10 years, that 8% gap alone costs him $40,000 in additional national taxes. And that does not include the regional income taxes on top of it. Consequently, your beneficiary designation does not just manage who gets the funds. It manages how fast the IRS takes their share. If the document is incorrect, or if the document names the incorrect person in the incorrect way, your kin pays the highest tax bill and there is nothing they can do about it after you are gone. And here is one more thing that amazes people. A power of attorney does not mend this. Many retirees assume that if they become disabled, their power of attorney can intervene and modify the beneficiary designations for them. Most financial firms will not permit it. A power of attorney normally permits someone to handle your funds and pay your invoices while you are living. It does not permit them to modify who gets the funds after you pass. Consequently, the lone person who can mend a beneficiary designation is you. And the lone time to do it is right now while you are still capable to make that phone call. Here's what to do this week. Step 1, contact every financial firm where you possess an account. Your 401k firm, your IRA firm, your life coverage firm, your bank, and your brokerage. Ask them one inquiry. Who is currently documented as the main and secondary beneficiary on my account? Do not guess. Do not trust your recollection of what you think you completed years ago. Get the actual name that is on record right now. Some firms can inform you over the phone. Others will post or email you a copy of the document. Either way, get it in writing. Step 2, match every single document to your current testament or trust, place them side by side. If any name on any document does not match your legacy plan, the document is what the firm will observe, not the testament. Modify the document pronto. Step 3. If you have a changeable living trust, ask your legacy lawyer whether any of your pension accounts should name the trust as beneficiary instead of a person. This is not always the correct path because of the tax consequences I just stated, but it must be a conscious choice, not a mishap left over from a document you authorized 15 years ago and never viewed again. Step 4, if you have been separated at any point in your life, examine every document across every account, even the ones you are sure you already modified, particularly the employer pension plan and the life coverage policy. Those are the two that families contest over in court more than any others, and those are the two where the incorrect name costs the most funds. Step 5, do not name underage children or grandkids straight as beneficiaries. Name a manager under your region's Uniform Transfers to Minors Act, or name your trust with specific rules for how the funds should be handled until the kid hits the age you select. One phone call to the firm that manages your biggest account could spare your family $400,000. So make that call before the end of this.